All right, I think we're live. We can get started here. Welcome, everybody. Today is Tuesday, October 4th. The time is 10:02, and this is the time and place for a meeting of the Cannabis Advisory Commission. So we will start today by having a roll call. Sarah, if you would.
I'll be taking roll in alphabetical order. Commissioner Chu.
Here.
Attorney General Ford.
Here.
Commissioner Boynes.
Here.
Commissioner Hammer.
Here.
Executive Director Hughes. Commissioner Nelson.
Here.
Commissioner Nickman.
Here.
Commissioner Ogden.
Here.
Commissioner Pearson. Director Tagliati. Assemblyman Yeager.
Here.
And Executive Director Cannabis.
Here. And we can note for the record that we have Yvonne here for Shelley Hughes sitting in. Thank you. And that Director Tagliati and Jenny Pearson are both excused for today. So with that, I think we can move on to agenda item number 1, which is public comment. If we have anybody, any member of the public wishing to provide public comment, please come up to the table. I got to fake out, so I don't see any in Las Vegas. Thanks for keeping us on our toes, though. So we will move on then to agenda item number 2. This is the approval of the meeting minutes. We have 2 meeting minutes to approve today or for consideration today. We'll start with agenda item 2A. This is the consideration for approval of the July 13th, 2021 Cannabis Advisory Committee meeting. Any questions, comments, concerns, edits from any member of the commission on agenda item number 2A?
Chair, this is Steve Yeager. I just wanted to note that I'll abstain because I wasn't on the commission yet for that meeting, so I don't have any basis to know whether the minutes are accurate.
Thank you. Anyone else? Okay, so I'll be looking for a motion then to approve agenda item 2A.
A motion.
Approved at second? Second. Commissioner Nickman. Great. All those in favor, please say aye.
Aye.
All those opposed? Great. 2A passes unanimously. Then we'll move to 2B. This is the consideration for approval of the November 9th, 2021 Cannabis Advisory Committee meeting minutes. Any questions, comments, concerns from members on agenda item number 2B?
I just had an edit. My name's spelled wrong on one of the section C.
Section C? Thank you for that. We will make that correction. Anything else? Okay, great. You're looking for a motion?
So moved.
Approve. Second? Second. Mr. Nickman, all those in favor, please say aye.
Aye.
Those opposed? Great. All right, so we move on to agenda item number 3. This is the reason that we are here today. This is the review of petition filed pursuant to NRS 678A.461D. Sala Consulting on behalf of RNBW. This is a petition to amend NCCRs 1, 4, 5, 6, 9, 11, 13, and 16. This item was requested by the Cannabis Compliance Board for this commission to review. The petition was originally presented at the Cannabis Compliance Board's July 26th meeting. All the commission members should have received the court reporter minutes, so you have an understanding of the item as it was presented, and then the follow-up discussion by the board. So we will start here with inviting the petitioner, Mr. Anderson, up to give a brief presentation of the petition. Again, Mr. Anderson, as I noted that the members here all received the court reporter minutes, so they have read your original presentation. Then we can provide some opportunity for any commission member here to ask any questions of the petitioner. And then we can also provide time to bring up any points of discussion outside of the presentation that relate to this petition as well. Once that happens, we'll move on to talking about how the subcommittees will meet, similar to the lounges, to discuss some of the ins and outs of the petition, and then we'll talk about timeframe as well during the future meetings. So future meetings items on the agenda. So with that, I'll turn it over to Mr. Anderson, if you want to give us a brief presentation on the petition in front of us.
Sure. Chris Anderson on behalf, with Solid Consulting on behalf of RMBW. This petition is intended to be sort of a trial balloon for cannabis at events. As we all know, cannabis is being used at public events right now. It's very prevalent. It's been prevalent for many, many years. And this is limited in scope, so it allows large events on the scale of, like an iHeart Radio Festival, Life is Beautiful, EDC, a large production with a lot of, compliance in place and a lot to lose, contracting with existing sales facilities to source product and sell product within designated areas at an event. That is the very high level scope of the petition. If it's helpful, I can also go through each regulation. Okay, so in Regulation 1, the petition is adding definitions of event owner, which would be the production. That would be like the iHeartRadio or Life is Beautiful. So definition of event owner, temporary cannabis event permit, which can only be applied for by a sales facility, and temporary cannabis event. Moving on to NCCR 4, the petition adds violations for offenses by temporary cannabis event permittees. In NCCR 5, the petition modifies inspections due to the temporary nature of a temporary event. So it just kind of comports with the transient nature of an event versus a normal inspection for a brick and mortar facility. NCCR 5, importantly, also enumerates application requirements. Temporary cannabis event permit is a one-time, non-transferable permit issued by the board to a cannabis sales facility, which authorizes cannabis sales and consumption in designated areas of the event. Temporary cannabis event permit applications are to be completed and submitted by participating retail licensees who have entered into a contract with the event promotion entity. So again, like Life is Beautiful, EDC, iHeart. Event owners must receive and provide proof of permission from the local jurisdiction. So it still depends on zoning rules and regulations at the local level. Applicants for a temporary cannabis event permit must not have a deficiency, unpaid taxes, or any other outstanding fees to CCB. The application also must include an event diagram with enhanced detail for any cannabis sales and consumption spaces. Must include the address. It also must show minimum of 25,000 people for the daily attendance of the event. This ensures, again, we're starting small by starting big. So we start with known entities that are very compliant right now. A lot of them employ law enforcement already, have emergency services. Ensures that the event owner has the necessary resources and wherewithal to conduct a private event, a compliant private event. The temporary cannabis event permit is for a maximum duration of 5 consecutive days. It must ban firearms and other weapons. They must maintain on-site emergency medical responders, and this is for outdoor events only. That's it for NCCR 5. Moving on to NCCR 6, the petition makes conforming changes to require events to comply with visitor procedures, training, SOPs, and security. NCCR 9, there's conforming changes to public health regulations that are already in CCB's regs. In NCCR 11, it's just conforming change to lab regulations. NCCR 13, there's an exception to delivery requirements to facilitate an agile response for an event setting to transfer product. And NCCR 16 is the new section that this petition creates for regulations specifically for temporary cannabis events. That's kind of an operations section. Most of the regulations in NCCR 16 were directly carried over from the consumption lounge regulations that were approved by the board in June. So this is going to read kind of word for word, a lot like the consumption lounge regulations. There is an addition of an ID check requirement plus wristbanding to prohibit polysubstance use at an event. And again, just like consumption lounges, this has a limitation for single sale products only, and the per sale limits conform with consumption lounge regulations. And lastly, in the operations section, the event must maintain on-site medical, emergency medical services. That is an overview and kind of a nitty-gritty of what's changing in each section. Happy to answer any specific questions about any of these changes.
I would just like to add before we start, so today, just for everybody's awareness, we're not going to take, action today on this particular petition, right? So this is about asking questions or having discussions about what we think the subcommittees should look at, or any other things that aren't included in this petition that the subcommittees should look at around cannabis events. So I just wanted to make sure that was clear. So,
and if I may, I was just trying to make all of your jobs easier by addressing some of those specific subcommittee,
absolutely,
issues.
Absolutely.
So if I may start, Jillian Nelson for the record. I am very excited by this. I think it's really awesome to have this expansion to the cannabis industry scope in Nevada, but there was two concerns that I did have with the proposed regulation changes. The first one here is the 5-day limit. So specifically, Burning Man is 9 days. So I do think that the 5-day limit might be a little bit short-sighted because many events do carry over above and beyond 5 days. So I think that might want to be reconsidered by the petition. Also, too, the event minimum attendance of 25,000 people. I believe that is going to really restrict the scope of what these events can be and essentially isolate it down to where these events can only happen in Las Vegas and maybe Reno. It really does isolate or exclude the rest of Nevada and our small towns from being able to have temporary cannabis events like this. So I'd also like that to be considered as well if possible.
James Hammer for the record. That was pretty much probably the number one thing for me as well, the attendance. While this is a limited scope kind of trial, I do think that that's probably one of the important things to look at is what is the minimum attendance kind of requirements for future events if this were to get passed into the legislation, because aside from even just the small towns, I mean, this really does limit it to some of the biggest event promoters. And, while we understand that they carry different levels of insurance and operating procedures, we want to make sure that this is something that people can participate in, separate from just, the bigger companies, is what I would say as well.
Aisha Goins for the record. One of my primary concerns is the licensing component. So if I may ask Mr. Anderson a question, the licensees that would be performing the services for these events, those are the current sales licensees. So we're not actually introducing a new license. We're just introducing an enhancement to a license is what you're proposing.
And in the petition, it's a permit, not a license.
So the reason why I'm asking is because you're actually defining, if I can go to that specification. So here it says owner defined relative to a temporary cannabis event. Owner means the person who legally controls the promotional entity that produces the event. So that would be basically the promoter, right?
That's correct. So this would, and just, as a normal function of business, you couldn't force a cannabis event, you couldn't force a sales facility onto an event. So the event has to decide which sales facility or facilities it wants to work with. They then enter into a contract, not unlike how an independent lounge, consumption lounge, would enter into a contract with a sales facility to source product. So they would enter into a contract with the sales facility or facilities that they wanted to work with. And then the sales facilities could apply for the permit.
So just so that I'm clear, what you're proposing is that the licensee, that the owner or the event promoter, if you don't mind me saying.
Sure. Yeah. Colloquially, we could
Okay.
say that.
So what you're proposing is that the event promoter is the curator of this, of the licensees that would have authorization to sell at these events.
Yeah, that's correct. And yeah, I mean, I don't know how, yeah, that was the only way I could envision drafting this, just because, again, you couldn't force a certain business partner on, an event, so they decide who they want to work with.
So my concern is that this is another extension of the current licensees. And it just, although I think the idea in concept is great, I also, one of the things that I hear the industry saying consistently is they want to minimize unlicensed use. And minimizing unlicensed use means, in my opinion, would mean that we need to create more opportunities, not keep giving the same opportunities. Not that I don't think that they're positioned to do that, but I will say in a pilot function, I think saying that an event over 25,000 is a good pilot space, and that is what this idea is. And when you say pilot, how long are you considering the pilot timeline to be? Because pilots have a beginning and an end typically. So what is your proposed pilot time for this?
Yeah, what I envisioned was that, again, this is so limited in scope that probably you'd see one or two events in a year avail themselves of this and be eligible for this, really. So it would give this group and the board a chance to see how everything is working at a really small scale. And then I kind of assumed that the board would either potentially create a new, more full-blown cannabis events regime in regulation, maybe after the first year or so. Or the legislature could certainly act if it saw fit to do so. Although the legislature did see fit to give this ability and authority to you and the board. So yeah, I envisioned it going for maybe a year or two until a couple of events happen. Okay. And everyone could learn more about what's going right, what's going wrong, and how we maybe expand this to more opportunities.
And so let me just ask another question. In here, in regulation, let me go back one. I think it's 5, subsection 1B. It is the affirming that the applicant controls liquid assets in the amount of at least 200,000. Are we asking for the event promoter to have the liquid assets? Or are we asking for the current licensees to show proof of another 200,000? So,
great question. The event promoter isn't really involved in the functions of, selling and regulating the consumption of cannabis. It's the current, sales facility licensee. So, all of the application requirements would apply to the sales facility, which would be, filling out this application. And I carried over the 200,000 in liquid assets from, sales facility application regs and consumption lounge. Certainly open to tweaks to that, but I just left it as is instead of making changes to that.
I have a couple more questions, but I want to yield the floor to, I don't want to just bombard, but.
Ben Chu for the record, I do have a couple of questions. In Regulation 1, you're saying this is issued to a cannabis sales facility. Unless I'm mistaken, I looked up an older version that hasn't been updated. I think sales facility is defined as a dispensary as opposed to a consumption lounge. And what I'm seeing in here is, you added regulations is consistent with the consumption lounge. And so that's my question is, are you limiting this to dispensaries or is this dispensaries and consumption lounges? And then part of that is from the regulations on the consumption lounges, my naive thought is that those licenses would have the most experience dealing with open use of this and making sure things are going legally that way. So I'm asking, the question is, are you aiming this towards dispensary or are you just redefining?
Yeah, your interpretation of sales facility is correct. I meant dispensaries. And, I put some thought into potentially adding consumption lounge licensees as potential applicants for a temporary cannabis event permit. But since there are no licensees actually operating today, I felt like again, to be as limited as possible in scope and to really focus on, allow people who have the most to lose to participate in this, to promote the highest compliance, to limit it at this point, to limit it to sales facilities.
Okay. The other question is, are we proposing any limits as to the numbers of these pop-up at any single event based on the size of the event? Or are we looking for enhancing competition in terms of sales wise? Or are we saying it's whatever the promoter or the organizer decides, hey, I want 1, I want 2, I want 10?
Yeah, in order to apply for this temporary cannabis event permit, the sales facility has to have a contract with the event owner. And so the owner decides who they're gonna, contract with. And there is no limit in this regulation as to how many sales facilities an event owner could contract with. There is the regulation in here that in the application, you show an event layout and detail of the consumption, the sales and consumption areas. And so I think that there's some leeway for the board to approve or deny an application based on the layout, and potentially if the board thought that there were too many sales areas. Yeah.
And then for, I guess, distance from schools, whatever, we're talking that one section of whatever the festival is, wherever they've carved that out, that is where you're defining how many feet from a school or whatever.
Right. I don't believe I've changed the measurements, the survey from a sales facility.
As opposed to the entire concert or festival space.
Oh,
right.
Well, that's something that we take a closer look at, whether you measure it from the sales and consumption area or from the property line of the event. Like as defined in this petition, it would be from the property line of the event. So it would be the most possible restrictive. Okay. And again, that's why, just trying to start very, very small, be very restrictive in kind of all of these provisions.
Thank you.
Any other questions?
I mean, I have a lot of questions. I don't know if you want me to just.
I'm with you.
Bring them on to something.
Yeah, Steve Yeager for the record. And so I had some along the lines that Commissioner Chu had, and it's interesting that you said it was the property line of the entire event, because I think about Life is Beautiful. It's massive, right? And if, if you can't leave the consumption area with the product, I just wonder if that's being too restrictive, although I understand there are competing concerns there. And then, with an event of that scale, I'm not an event planner, but I think about Life is Beautiful. I think they have multiple bars, multiple restaurants, and multiple sections. So I just wonder about the success if you were to limit it to just one area or one vendor. Easier to contain, obviously, but so I think those are some things that can kind of be ironed out. But in terms of questions that I had, you didn't mention Burning Man in your opening remarks, but Commissioner Nelson did. I imagine the reason you didn't mention it is there's a federal issue there because it's federal land.
Yeah, I've not seen an ability or desire on their part yet to apply. But I absolutely don't intend to exclude Burning Man. But yeah, I think there's some other concerns there. And
I just meant that it's BLM land. So
yeah, exactly.
Being that it's a Schedule 1. And so I just,
right.
Obviously that's a discussion for later, but I just wonder if there would be a way to accommodate that use, but it would have to be outside of the actual event, which poses some, potentially some issues. And sort of leads to another question, which I had is Burning Man's a good example because I don't think there are any dispensaries really close to Burning Man. I think you have to go all the way down to Reno to find one. And so I just wondered if there were any concerns about wherever your event is, you're transporting product from a dispensary, or I guess it could be from somewhere else, but you're having to transport that product. And I would think you're transporting a lot of product. If there's any concerns about that whole transport, because it's not like you're walking into a dispensary and the product's already there, like you're having to move potentially a lot of product and potentially a lot of cash coming back because there'll still be cash sales until the federal government changes that. So just wondered if you had thought about that, if there's going to be additional requirements for that kind of transport of product and cash back and forth between potentially multiple dispensaries, if multiple dispensaries are licensed to participate in one event.
Yeah, I thought about that. That's again one of the reasons why this petition was limited to sales facilities who have and comply with a lot of security requirements already. The licensees who are here would attest that if they're following those same procedures in an event setting, I think we can ensure adequate safety. Maybe we need to add some. Well, I'm not going to speak for the commission in terms of additions, but you could think of maybe some enhancements that could be added in this petition if that remained a concern.
Right, and some of these I just throw out because it sounds like we're going to have some subcommittee meetings, but maybe just things to think about. I was interested that you said there would be sort of an ID check and a wristband system to prevent polysubstance use. Was your vision of this that in the designated area there would be no polysubstance use, but could a consumer come into like a Life is Beautiful, get some alcohol at one of the concessions and then come into the consumption lounge? But so just, is it no polysubstance or just in designated areas? And just kind of thinking about some of the logistics of maybe different colors of wristbands and like if you have multiple places where product is being sold, like how you kind of police the traffic going back and forth in some kind of way.
Yeah, so the mechanism that I sort of envisioned for that was that and look, let's be honest, all this is happening today. Sure, it's just happening illegally. So let's give licensees a chance to compete with the illicit market. But to address your point, the system that I envisioned was you get a verified electronic wristband when you buy product in a sales and consumption area, and you cannot, once you have that, you cannot buy alcohol or anything else from let's say an alcohol vendor from elsewhere inside the event. And the way to enforce that is if somebody brings in number one, there's no weapons, but people can pull off wristbands, whatever, but then you would not be allowed back into the sales and consumption area.
Okay, great. Could I ask just a couple more?
Yeah, absolutely. This is what we're here for.
So one of the interesting things about outdoor consumption, right now dispensaries, you're not consuming there, but the product is inside. So now we're talking about having product outside and outdoors. And I don't think a lot of these events happen in the summertime, but the weather is a thing. And so I just, I'm not the expert on this, but I just wonder about how well does product hold up in those kind of conditions. And so maybe it's something for one of the other committees to just think about, because I think I saw that you had a sort of, there needs to be a barrier or display or something, but I would be sort of worried about product sitting out there all day as well, which presumably is why you had the requirement that it has to be destroyed if you don't sell it, because I don't think you really want that product to be out there all day and then going back into the dispensary. And so just kind of wanted your thought on that. And, again, I'm not in this industry, so I'll give it to our dispensaries, but it seemed to me there'd be some challenges to figure out exactly how much product and what you need to have out there, given the demand. So just wanted your thoughts on that. And I know it's kind of an amorphous, just really a chain of thought rather than a question.
Yeah, no, it's a great thought. You know, again, I'd go back to the point that, you know, this is obviously happening right now. So people are figuring out ways to, you know, make product attractive to, you know, the consumers are, you know, sourcing product. However, I mean, maybe bringing it from out of state or getting it from illicit sources on the strip or whatever before they go to the festival. But yeah, I think this is a great opportunity for some innovation in the industry for, you know, for preservation of product, you know, all of those things. You know, that might come up, and I think our sales facilities are, you know, well informed to deal with those kind of issues that pop up. And to your point about the time, actually all of these, you know, events in question are in the summer, May, June, July, August. That is the time frame for every event that would qualify, you know, under that I know about that would qualify under these rules.
I think to add to that, the destruction could potentially be pretty costly for the sales facilities if that was a requirement of, you know, once the event's over. So I think maybe if you were looking at it from the perspective, you know, making sure the product safety and quality is there, but outlining very specific things on, you know, what would qualify as good standard practice on that and not allowing or not, you know, requiring product destruction potentially. You know, if you're estimating, let's just say for discussion purposes, 100,000 worth of inventory, and then you only sell through 60,000, you know, that's effectively, you know, pretty big loss on destruction, which, you know, we can even realize right now in dispensaries just through returns and everything else that happens too. So just kind of want to note that and maybe something to look at there too.
And to your point, I'm glad you raised that. The destruction doesn't apply to you. You know, when a sales facility transfers product to an event, they transfer it back to the sales facility. You're not destroying everything that you don't use. You're destroying unused product that the consumer has.
Got it.
Just like consumption lounges. So people can't leave the consumption area with product, and, you know, sales facilities have to destroy everything.
So the minimum requirement of single use that you had in here is like an eighth, right? 3.5 grams.
Yeah.
If they were to not consume all of that, then they would be checked on the way out and then that product would be disposed of. Okay. And the destruction, obviously, there's process in place at the retail facility that's, you know, depending on what type of product it is, can actually, you know, have its own level of cost and or like unique requirements. So that may be another thing to look at too and how that actually functions. Maybe it's put into a bin and then destroyed at the end of the day, but something to consider there too.
I have a couple more.
Absolutely.
So I was thinking about liability if something goes wrong. So we have an owner or effectively a promoter of the event, and then we have the dispensary. I mean, do you think the regulations would touch on that, or would you leave that between the contracting between those two entities to just figure out if something does go wrong, who's going to be on the hook for it? I mean, obviously we have the regulatory authority, but I wonder about that and what your thoughts are.
Yeah, I was going to kind of just leave that up to private business, and, you know, the licensee and the event, you know, promotional entity could decide if they, you know, add any new provisions like that to their relationship. But yeah, there's nothing in these regs that touches that.
Okay, great. And the last one I had was, I know it was discussed a little bit about at the board meeting, but there was a piece of legislation last session, which I think was AB 322, that had a similar concept to this, but not the same. And so I just wondered if you could at a high level talk about how your petition looks different than what the legislation looked like. And because I think ultimately, I think that legislation did not get a vote out of committee, or maybe it got out of committee, but it didn't end up passing the legislature. So if you could maybe highlight how this is different from some of the big concepts that were in that bill.
Yeah, at a high level, as I recall, that bill had a new licensee type. So that's obviously a whole new thing for the board to stand up. That's probably the one biggest thing. When you're adding licensees, that's like adding consumption lounges. You know, you're adding a completely different regulatory regime to the NCCRs. Additionally, I believe it allowed that there weren't very many restrictions on what kind of event could qualify. Please, anyone here correct me if I'm wrong, but that a lot of different events could qualify. And I think there was a broad concern in the industry, or maybe I was concerned when I saw it, that could have had the effect of creating a lot of de facto dispensaries. which is something that we obviously do not want to do with our sales facilities under a lot of pressure today. So this is much more limited in scope in terms of how many of these events would occur and also not creating a new license type.
That's all I have for now. Thank you.
Michael Lickman for the record. I have one question with regards to agent cards. So let's say 25,000 people, that's a very substantial amount, naturally requires enormous amount of people to cater. Right now, the industry, the way we work, thank God the CCB has finalized we can get our temporary cards in a matter of a day or two. Will we allow individuals with temporary cards to sell the product? Individuals that almost no training. One thing when we get an employee from a dispensary or from the industry, they've been trained, they work X amount of weeks, months, whatever the case is. In the catering settings, big weddings or whatever the events, you just hire people. So the concern of compliance issue, somebody gets an agent card within a matter of a day, throw them in there, what happens then?
Yeah, I didn't put any additional regulations in terms of agent cards beyond what a sales facility, would have to have today. So there's some flexibility for them. But I would just, fall back to the reality that I think a sales facility is going to be very careful about participating in a pilot like this because their license, again, is at stake. All the violations in terms of product diversion, things that could happen, all those violations apply here. And I think everyone here knows that the board is going to be, pretty vigilant when it comes to making sure that things are running correctly.
Or maybe to eliminate facilities to getting expensive bills and getting reprimanded, something to consider that a person qualifies to participate in events like that actually has a physical agent card. At least we know that individual has been vetted properly and has been X amount of days working already at the facility instead of just an overnight thing. Something to consider.
Yeah, it's a good suggestion.
Thank you.
I have a few more questions. Aisha Goins for the record. So my first question is, in the idea of the $200,000 having to have that, were you thinking that the licensee had to show proof of that every time they wanted to host an event, or do they qualify to be an event owner, any sales event owner one time and then it qualifies them each time?
Great, excellent question. This is a one-time non-transferable permit, so you're demonstrating those liquid assets every single time.
Okay.
And again, not too many of these events, so you're talking maybe like once a year they reapply for a permit, which is a good opportunity, frankly, for the board to go in, make sure that everything's on the up and up with the licensee. It's another opportunity to check compliance.
I have a question about Regulation 5, subsection 1G, and I'm just going to read it, and if you can tell me, because I don't believe that I'm interpreting it correctly, so I want to hear the interpretation of it. If the proposed temporary cannabis event is not owned by the applicant, evidence that the applicant has entered into a contract with the proposed temporary cannabis event owner. Can you kind of elaborate on what you're saying there?
Yeah, what I meant in that provision was that, in the unlikely scenario that the cannabis sales facility actually is the event owner, the promoter, that we're not prohibiting them from putting this on. So assuming that the sales facility is not the owner of the event, but if they are, so if they're not, then they show proof that they've entered into a contract with the event. And if they are the event owner, then they're the event owner and they're applying kind of on behalf of themselves.
So let me make sure that I'm clear on this. So what you're proposing is that there is a possibility that the event owner and the event licensee, that would be the event sales licensee, could probably be the same. And this language is saying that they would have to then contract someone to be the curator of the sales at the event that is owned by the licensee. Am I correct?
So I'll just kind of reiterate one more time. So basically, so this is what is envisioned in the petition is that an existing event, let's just say Life is Beautiful. Life is Beautiful wants to add cannabis sales and consumption to their event. So, if that event meets all the metrics that are in these regulations, they go out and say, hey, XYZ sales facility, do you want to come in and be the, event sales and consumption source? And they say yes, they enter into a contract. And at that point, dispensary XYZ can fill out this application, but you can't apply to be an temporary event permittee for an event that you don't have no relationship with the event owner. So if I own a dispensary, I can't just, apply here and plop down at Life is Beautiful. And meanwhile, the promoter of Life is Beautiful is kind of freaking out at me. So it creates that relationship prior to this application. But, again, clarifying the provision that you reiterated, I left it open so that if in the unlikely event that the sales facility did own Life is Beautiful, then they wouldn't need to show a contract themselves, But yeah, basically the way that this will work is a sales facility contracts with an event, then applies, gets the permit, and then operates all the sales and consumption at the event.
But if an event owner is also the owner of the licensee, they would have to contract someone to facilitate being able to sell at the event. I just want to make sure that we're saying the same thing.
Yeah, there's nothing in between the event and the dispensary.
Okay.
They have the relationship, and that's how this works.
But if the event owner and the licensee are the same, then how does that work?
They won't be, but if I own Life is Beautiful, then I just decide to have sales and consumption, and I go ahead and fill out this permit application.
Okay.
Ask a question on that. So are these 25,000 plus person events, can they be, I guess in concept, a new event that isn't currently existing? And, with that, right? So maybe, and what she's bringing to the table is, for example, I have a dispensary, want to start an event and, said, okay, this is going to be 25,000. I could then essentially create an event, put my dispensary in the event, right? That's also okay.
Correct.
And then with that, how, aside from, submitting a business plan and or a marketing plan related to an event, with the scope of budget, probably assumed within it, are we qualifying an event with 25,000 plus people with no historical record? Like, could someone essentially say, I'm going to be putting on this event, our goal is to sell 25,000 tickets, come 15,000 tickets short, but then still be able to operate the dispensary in the event?
I think the board would have some flexibility to revoke the permit or not issue the permit. There is a provision in here that you have to demonstrate, a reasonable expectation of that level of attendance. So you'd have, there'd have to be some kind of proof.
Aisha Goins, for the record, I do want to say that I think that it's a conflict of interest for an owner of an event and also the facilitator of product in the event to be the same. So if you wouldn't consider, I hope that you would consider adding that as a prohibitor in here. And the reason why I'm saying that is to what this gentleman next to me is saying is it creates an opportunity. And I realize that this is a pilot, but if the pilot then is executed and effective, then that could become regulated. And so my concern would be that then the licensees become event promoters. And that's not the business model that the cannabis industry has been positioning. And I do realize that we are looking for the expansion of this industry and what that can look like. But then also it presents a special and unique situation where we in Las Vegas, Nevada, and Reno, Nevada, we attract new events. We attract specialty events. And I'll just take Formula One, for example, right? And what we don't want to do is then get into a place where we're the ones monopolizing the creativity and the idealism of events. And so having a space where we're saying the owner and the licensee can be the same, then kind of pigeonholes the creativity of what Nevada is known for. And so I would consider that a little bit of a conflict of interest. And then also, I just think that those two parties should be separate, because then you know that there's less opportunity for manipulation, and we always want to, be transparent and be forward facing. I do just have one more question, and I know that the petitioner and I have had conversations about this, but I want to see further what he is considering as it relates to social equity and inclusion and diversity for even the pilot, because what I don't want to do is be in a situation where any new licensing ideas, because you wouldn't consider this a new license, you would consider this an enhancement. But I do agree with Commissioner Chu. I think that this is better suited under the consumption lounge than the current sales licensees. But I want to know what your idea is as relates to social equity and inclusion, because that has been the focus of all new and licensees moving forward. So what are you thinking as it relates to this pilot?
Yeah, so I'll address your first question first, if that's all right. So in terms of separating and making sure that a dispensary can't get into the event promotion business, there's nothing exclusionary in the language of the petition in terms of like only a dispensary can, create a new event. So I kind of actually think that excluding dispensary owners from being able to do an event, actually that would stifle creativity if they have the wherewithal to go ahead and create something on this scale. I'd certainly be open to changing it. It doesn't affect what I'm trying to do, but I'm not sure that we should necessarily go there. Just kind of putting that out there. And then onto the social equity side, again, since this is so small, I just didn't seem like the right spot to, kind of add a new program for social equity. But one of the things that I've thought of, since I submitted this petition is that it would be really good to somehow foster, experience and relationships for potential future social equity applicants or players in this space. And so maybe I think it could be a really good idea to like bring in some kind of a training / like mentorship program, even into the pilot, so that social equity, people who would qualify as a social equity applicant, if this events regulation is expanded, maybe, kind of bringing some folks in at the ground floor and seeing how you would operate a compliant event like this. Just an idea that I had.
Any other questions? What's the discussion? Yeah.
Michael Nickman for the record. I know it's been already brought up and you already answered the question that this particular petition, just an overall, specifically pertains to dispensaries. And your reasoning was that consumption lounges, we have yet to give out licenses, but they are coming, right? They are coming, they'll be here. And part of those consumption lounges, they do have minority licenses. So why not include that word of consumption lounges into that, so that we don't have to come back afterwards and change the rules, change the regulations, add something. It's already there, and consumption lounges, like dispensaries, like any other licensees, we're all under the same rule. So if consumption lounge decides they would want to participate in the event, they actually have these abilities without, now we have to get an approval from the CCB and just kind of start this process over.
Yeah, I
potentially kill, two stones, one thing, and we do have minority licenses that we'll be giving out, and this way automatically they will, any license will be eligible to host an event as long as they naturally meet all the criteria.
Yeah, there are some arguments, I think, in favor of including consumption lounge licensees as potential temporary cannabis event permittees. There's a lot of synergy there. I think it makes a lot of sense. It would be really awesome to bring in social equity consumption lounge licensees into something like this. On the other hand, and this is kind of what, kind of won out in the way that I was weighing this, consumption lounges might fail. I don't know. I've never seen one. I don't know if they're going to do well. I don't know if they're going to be compliant.
But at the same time, we have, in order to even eligible, you need to meet the criteria. In order to get a license, you need to meet certain criteria. So if it's there, it's just an opportunity to apply. The rest is being still decided by CCB and very rigorous rules that will come afterwards. And I'm sure that everyone is for them because for the first time, we'll be catering to that many people at the same time. Security aspects, which will bring an enormous amount of product. The head is just spinning from what CCB has been concentrating over the years as far as, I can't even imagine thousands and thousands of jars and how to take an account or something drops, it's a nightmare world.
Exactly.
But eventually, my point or my ask is we include this and it just gives the abilities, is what my colleague brought up, right? We want to include, we know that there'll be minority licenses. It's just we're doing everything at the same time. We're just giving an opportunity to say, well, if you meet these criteria, you're eligible. Why are we excluding, if they're going to fail, they're not going to be eligible to apply. So it's not a concern that we should be even thinking about.
Well, I mean, on the other hand, I think we've seen with other licensees who eventually have gotten their license revoked, there's a lot of problems, very concerning things happening before their license gets revoked, before you see anything on paper where that licensee is having trouble. There could be major trouble behind the scenes. So again, I just made this the smallest, most kind of compliant, using the oldest licensees to, you said it could be very complicated to carry out the sales and consumption at an event. Why not use the, folks who have been doing it the longest,
What if someone just got their license transferred in the last half a year? They took over somebody with very limited or simply no experience. So do we exclude them? Is there a limitation? You need to be in business for X amount of years with clean record for 2, 3, 4, 5 years to be eligible? Or if I'll obtain a license tomorrow, I'm eligible just because I have a dispensary license?
If this commission and if the board see fit to expand the licensees that could qualify for this permit, I'm completely open to that. Yep, and that's your decision.
I have one last question, and I was debating on if I should ask, but since it's in the forefront of my mind, the permit fee is $2,000. And so my question is there one permit fee or shouldn't there be 2 permit fees? Like, shouldn't there be a fee for the event host and a fee for the permit holder? I guess I'm thinking about like any other licensing, a petitioner has to put in a fee and then the person. So for example, in beer and wine caterers, the holder, the event has to put in a petition that they want to have beer and wine events. And then the beer and wine host has to pay a fee to be at the event. And so this just has one fee. So I was just questioning that.
Yeah, only sales facilities licensed by the CCB can apply. So that's the only person you could charge a fee from, as far as I see. We could create some other mechanism, I guess, if money is the problem, or we could just, increase the fee. But yeah, I wouldn't want non-licensees all of a sudden having some kind of a relationship with the cannabis regulator in the state. I'm just not sure how that would work. But if we need to look at maybe increasing the fees, since there is someone else sort of tangentially in the discussion, we could take a look at that.
I guess what I was thinking is that if the event, and we're talking about, relatively 2 events, you've been clear about that because we're talking about a number of events, a number capacity. But I just think that, and maybe, my mind isn't thinking correctly, but I think if the event wants to have, if they have to qualify, if we're saying that the event has to qualify for 25,000 people, then they're the ones who would have to petition to say, I know, these are my numbers, this is my status, this is how I know that this event has 25,000 and I would like to have sales at my facility. And then the CCB would send out, this is my thinking, right? And then the CCB would send out a petition to all licensees saying, this event has qualified as a candidate for the pilot program, and submit to them if you're interested in being a sales facility for this event. Because otherwise, 2 things are at play, like how does the Cannabis Compliance Board know that they qualify? Are we expecting the sales facilities to qualify the event? That I just think that that's kind of, and I'm not putting more work on the Cannabis Compliance Board by any means, because I know, you're overloaded, but I just think that I don't see any other way of how that event would qualify themselves. That's my last comment.
Yeah, I would just say that, sales facility has to apply for this permit. They're the only ones who can, provide this information. Obviously, the board is going to be able to decipher whether the information is accurate, ask any follow-up questions, and potentially deny the permit application if they're not satisfied that the application meets all of the requirements, of which the 25,000 minimum attendance is one at this point.
Okay.
Just a couple, hypotheticals. I wanted to get your take on whether, under your vision, these could apply. So, like, one would be NASCAR, which I think is probably over 25,000 people, but parts of that event are inside, parts are outside. And then another example, which we have to change the facts a little bit, but think about like Consumer Electronics Show. Obviously on the Strip, you're going to have 1,500 foot issue with gaming, but they have a lot of stuff that's outside as well, right? They've got convention halls inside, but they have big displays outside. And I just wondered, in the right scenario, if they came forward and said, look, we're having a big event outside, there's going to be bars there, and we'd also like to have a cannabis consumption area. Do you envision the way that this petition is drafted that situations like that might potentially be covered? Or does it have to sort of be exclusively big, huge outdoor things like Life is Beautiful, like Burning Man, like iHeartRadio, that sort of thing?
The latter is what I had envisioned, but I think there's flexibility here for the board to determine, okay, you meet the attendance requirement, the sales consumption is outdoor only, maybe you've met the requirement.
Sure, please.
I think I have a random question. So the Department of Taxation is currently getting prepared to adopt a regulation about the taxation for the consumption lounges to confirm that it's the seller, the retail seller, that's responsible for the taxes. But in this instance, it's not going to be the event planner or the event owner that would be selling the product. And this contemplates only that the retail cannabis dispensary would be selling it. So they'll still be so we don't anticipate the need for any sort of regulation to confirm that it's going to be the cannabis retail seller that's going to be responsible for the tax reporting.
Yeah, I did not intend to change any of that. And just the assumption is that the retail facility selling, all the normal taxation rules would apply.
Any other questions, comments? Again, this won't be the last time.
Could be.
You asked the petitioner, it would be the last time. Okay, well, just speaking for myself, I mean, I think this is exactly the kind of conversation we were all hoping, and the board certainly was hoping to get out of this commission meeting. I mean, this is the reason this commission is in place, to have these conversations. I wanted to add to this, something that the board discussed was input from law enforcement. I think if Director Tagliati was here, he would have said that as well, but the board brought that up, and just making sure through this process, through the subcommittee on public safety, that local and state law enforcement at least get a chance to come in here and have some conversations. I mean, Mr. Anderson, you brought up, obviously, the issues on polysubstance use. You've addressed that within the petition, but that is obviously a topic that's, top of mind for law enforcement, top of mind for the board. So something I wanted to make sure that was on the record as part of that discussion or the future discussions. So with that, thank you. Appreciate that. We can move on from at least the discussion on this item. And then we can move on then to agenda item number 4, which will be future meetings. So given the way the consumption lounge process worked, that's the pathway that I know the board and I feel comfortable, and I think this body should feel comfortable moving forward with for this particular petition. So that would be the subcommittees on public safety, public health, and social equity meeting to discuss this particular petition and a lot of the items that were brought up today. I mean, that's going to be where the work is done on that. I would also like to see the subcommittee on market stability meet as well. It has not met yet, but I think as just good policy, good practice, when we're talking about anything that would introduce new sales, consumption, et cetera. You brought up, Commissioner Nickman, agent cards, which was that to me, the market stability subcommittee is the perfect avenue for issues like that to be discussed. So I've asked Sammy Rial from Clark County, who's on the subcommittee, to act as interim chair. And so that subcommittee will also meet as part of this. Time frame, the board had some discussions about this as well. With legislative session coming up in February, the board would feel most comfortable if we were able to flesh this issue out prior to legislative session, so that the board is armed with information on events and information that they may need to bring as far as resources. And so I do think it's reasonable that if we set 60 days for the subcommittees to meet, and provide and gather some recommendations that they would then bring back to the commission. I think that is a reasonable time frame. Obviously, we'll see how the meetings go. Our staff is here to help facilitate those subcommittee meetings. But if that's the case and we do get some recommendations, we could see potentially a December advisory commission meeting where we all come back and look at the recommendations from the subcommittees. Maybe it's right then for a vote to send to the board. But if we set that as a tentative time frame, unless there's any concerns with that, I think that is fairly reasonable for all 4 of those subcommittees to meet. Any questions, concerns with that? Okay. Well, then I will close the book on agenda item number 4 for future meetings as well. And that will then bring us to the last public comment period. So I'd ask if any member of the public wishes to provide comment at this time.
Just going to note, there were some virtual folks that texted me that said they didn't have a chance to comment. Are you allowing comment from virtual?
I don't believe we're allowed for virtual comment for this meeting.
Well, they heard that. Confirmed.
Yeah, please.
Chandler Cooks for the record. Thank you all for this workshop. Very interesting, the proposed pilot. And sorry I'm late, but it seemed a bit familiar to what board member Nylander spoke of, AB 322. And I heard the distinctions with it not being a new licensing type and having the restrictions on which events qualify. But I have some concerns. I certainly agree that it's time to begin bringing cannabis sales and consumptions at events under the CCB's purview. but I'm not confident that this proposed measure is a suitable way to start. My biggest concern is the lack of access for unlicensed people. The unregulated activity that currently exists at events presents an opportunity to provide additional licensing to the public. Even more so, there should be no additional licensing or permits awarded without opening that process to qualified social equity applicants. With the crackdown on unlicensed businesses, offering an equitable opportunity for ownership in this industry is essential to the healthy development of it. And the restrictions set forth in this petition don't allow, in my opinion, the flexibility and opportunity to develop relationships or foster creativity. Thank you.
Thank you. Is there anyone else? I would add, if there are folks online that would like to provide public comment, please go ahead and submit that public comment. We will absolutely, after the meeting, post that online as part of this, this notice on the website. So we'd be happy to do that. Right. I guess with that, unless there's anything else, we'll move to adjournment. Thank you all for being here. Look forward to seeing some of the recommendations coming out of the subcommittees.